The item for consideration is H.R. 6063, offered by Representative McCollum. I ask unanimous consent that the Subcommittee for Indigenous Peoples of the United States be discharged, and from further consideration of the bill. Without objection, the bill will be considered as read and open to amendment. I now recognize Representative McCollum to speak on her legislation. Representative, you're recognized.
Thank you, Chairman Grijalva. H.R. 6063 will enable the Miami Tribe of Oklahoma to pursue a settlement case in the U.S. Court of Federal Claims to resolve a treaty-based land claim in Illinois. This bill confers jurisdiction on the Court of Federal Claims to hear, determine, and render judgment on the Miami tribe's case, while also extinguishing the tribe's claim to the land. It would permanently clear title for landowners on 2.6 million acres in eastern Illinois. The legislation extinguishes the land claim in exchange for the tribe's day in court, regardless of the tribe's success in litigation. Approving this case in court would be up to the tribe. The case is based on the protection of the Miami lands with Illinois by two treaties: the Treaty of Greenville in 1795 and the Treaty of Grouseland in 1805. The Treaty of Grouseland specifically required that no further cession of tribal lands could occur without the consent of each of the signatory tribes, including the Miami. The Miami tribe never gave that consent. In fact, the tribe contends that the United States never even sought to obtain it. But nevertheless, those treaty-protected Miami lands were patented to non-Indians over the next 150 years. To be clear, this bill does not render a judgment regarding this claim, nor does it authorize any payments to the Miami tribe. What it does is it gives the Miami tribe the opportunity to have their claim heard and decided by the Court of Federal Claims, while completely clearing the land title forever to the holding private landowners harmless. The solution is one supported by the Illinois Farm Bureau, and I submit for the record their 2019 joint statement with the Miami tribe in support of this approach with both their signatures on it. Mr. Chair, without objection, I hope you will take it. And I finally want to thank Chief Langford of the Miami tribe for entrusting me with the sponsorship of this language. And I also want to thank my colleague and co-lead on this bill, Representative Mullen of Oklahoma, for working to advance this legislation together and bipartisanly. It is truly an effective, fair, and bipartisan remedy for both the Miami tribe and those Illinois landowners. And I urge support for this legislation, which is a solution to a problem of failure to recognize and engage the Miami tribe back years, decades ago. I thank you, Mr. Grijalva, and I yield back.
Anyone else wish to be recognized on the legislation?
Mr. Chairman,
Sir, recognized.
H.R. 6063 does aim to settle a proposed tribal land claim, but in so doing, it would open past land claims after the statutory deadline to bring these claims has passed. The Miami Tribe of Oklahoma originated in the Great Lakes region, but was removed to Kansas and finally to Oklahoma by the U.S. government. In 2000, the tribe filed a lawsuit against homeowners and farmers in Illinois, claiming 2.65 million acres of the Wabash River watershed as rightfully theirs. A court ruled that the tribe could only file this lawsuit against the United States, not private citizens, and the tribe withdrew. H.R. 6063 is fundamentally a waiver of the United States immunity from a suit that could have been but was not filed by the tribe during the period when the Indian Claims Commission Act claims were required to be filed. The ICCA bars tribes from bringing certain claims before the Court of Federal Claims if they were not filed by 1951. And I'm quoting from that. It says, so that no tribe could come back to Congress 10 years from now and say that it had a meritorious claim, end quote. While H.R. 6063 aims to resolve the proposed land claims of the Miami tribe by giving the tribe more time to file land claims, it is doing exactly what Congress intended to prevent with the ICCA. The bill would open up past claims and prevent the United States from asserting a defense against these claims based on the tribe's filing timing. For these reasons, I oppose the bill and yield back.
Gentleman yields. Anyone else wish to be recognized? Is there any further debate before we begin the amendment process? Without objection, the ANS offered by Representative McCollum is considered as read and open to amendment at any point. Are there any amendments to the legislation? No. If there are no amendments, the question is on adopting the ANS. I will pause so the members joining remotely can unmute. All those in favor, please indicate by saying aye. Aye. All those opposed?
Aye.
I always forget to pause. All those opposed indicate by saying no.
No.
In the opinion of the chairs, the ayes have it, and the ANS is adopted. The question is on adopting the legislation as amended and ordered favorably reported to the House. I will pause now so the members join remotely can unmute. All those in favor, please indicate by saying aye. Aye.
Aye. Aye.
All those opposed, please indicate by saying no.
No.
In the opinion of the chair, the ayes have it, and the bill is adopted as amended and ordered favorably reported. The motion to reconsider is laid on the table.